This morning. Let's see. We will get started as soon as courtroom 2 comes online. Morning,
Morning.
Ms. Lewis.
How
How are
you?
you? I'm doing well. Yourself?
I'm here. We're gonna get
Okay, good.
I think they sent some pre-orders to you in advance. They CC me on it, I think, of some pleas paperwork on position 39, 40, 43, 44, and 46. They were already sent to me, and I think they CC you on it.
Okay, they must have sent it to the Fulton County address. If you wouldn't mind, would you send it to my
Your other address, okay. I
All
will.
right, thank you. I appreciate it. Morning, Ms. Falk. Hope you're well this morning.
Good morning, Your Honor. I'm sorry. I just heard my favorite word, please. So I came on, came on the video. I do want to apologize to everyone for kind of some of the revised offers. We did receive some late information that changed the nature of our offers on a few cases.
Okay. There's an issue. Just let me know when we reach those individuals.
I will, Your Honor.
Thank you. Okay, we'll get started as soon as courtroom 2 comes online.
We hear you, Honor.
Oh, okay. Good morning.
Good morning, Judge.
Good morning, Mr. Haddad. Hope you're well this morning.
I'm doing fine. Thank you, sir.
Excellent. Let's see, where would you all like to start today?
Well, I have, we can start with position number 33, Judge, Roger Ricks. That's ready for a plea, Judge. I got a chance to speak to him this morning, which is why I was unable to, we couldn't find him yesterday, so he's here.
Okay, glad that you were able to raise him. Good morning, Mr. Ricks. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are completing by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you, sir. You can place your hand down. Ms. Falk?
Yes, Your Honor. The state's recommendation in this case is on count 1, dog at large, 12 months probation, serve 30 days, credit for time served 15 days. That's going to be from February 20th to March 5th of 2024. Balance probated. There is a $500 fine, 40 hours community service, and we are requesting the defendant take an animalcourts.com online course. Count 2, 3, and 4 will be 12 months probation concurrent with count 1, which is the dog at large and 2 nuisance counts. And count 5, the reckless conduct count, will merge with count 1, the dog at large. The state is requesting the defense stipulate to venue, factual basis, and identification for the purposes of the plea. We are not opposed to non-reporting status upon completion of the conditions. That is all.
Thank you. Mr. Haddad?
Thank you, Judge. Judge, on behalf of my client, I just wanted to mention that the reason he missed court is he has been in custody, continuous custody in DeKalb since October of 2021. And I was just informed. I think I can check that, but in any event, this is a negotiated plea. We do stipulate the venue, factual basis, and we just ask the court to follow the state's recommendation. That's it, Judge.
Okay. Mr. Ricks, it's my understanding that in case 19 CR 0000871H, you wish to plead guilty to 2 counts of dog at large and 2 counts of nuisance. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Ricks, let's see. As soon as you complete the terms of the probation, it'll go to a non-reporting status. So the quicker you get it done, the quicker you won't be on reporting probation and don't have to pay those fees, okay?
Okay, thank you, sir.
All right, good luck to you, Mr. Ricks.
All right.
Thank you, Judge. Judge, whenever the court is ready, position number 35 and 36, Markel Seabrooks. Ms. Falk, same announcement. I couldn't find him yesterday, but he is here. We're ready for a plea.
Okay, very good. Good morning, Mr. Seabrook. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah. You gotta speak up.
Thank you. I heard you, Mr. Seabrook. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, thank you, sir. You can place your hand down. Ms. Falk?
Yes, Your Honor. On this case, on the first position, the criminal trespass charge, the state's recommendation is time served, 34 days, credit for time served, 17 days. That's going to be from July 28th to July 29th of 2023, and then again from February 20th to March 5th of 2024. The state would ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. Position 36, the state is tendering a null pros. And that is all for the state.
Sadad?
Thank you, Judge. We do stipulate to factual basis identity. Now let's forget the third one. But anyway, and venue. We'd ask the court to follow the state's recommendation, Judge.
Okay. Mr. Seabrook, it's my understanding that in case 23 CR 004683Y, you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation? You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
You need to say yes or no.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Good luck to you, Mr. Seabrook.
Yeah, we don't need the rights. Turner, Robert Turner.
And Your Honor, is it Miss Lewis who's accepting the FTA null process today?
Yes, it is.
Okay,
I am the litigation manager for today, so send all your paperwork to me.
I appreciate it. Thank you, Miss Lewis.
You're welcome. I'm double dutying here today, Judge. So I'm Zooming and litigation here.
Okay. Let me know if you need anything, Miss Lewis, okay? Yes, who do we have?
Your Honor, this is position number 42 and 43, Robert Turner. I submitted the plea paperwork late last night, Judge.
Okay. Good morning, Mr. Turner. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can place your hand down, Mr. Turner. Falk?
Yes, Your Honor. In this case, the state is on position 42, entering a null pros upon the entry of this plea. On position 43, the criminal trespass, the state's recommendation is time served, 50 days, credit for time served, 25 days. Just to clarify, the defendant was in East Point Jail from September 4th to September 15th of 2021, and then February 22nd to March 5th of 2024. So we would like the East Point Jail time to be added to that calculation since it's on that case. And the state would ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. That's all for the state.
Sadad?
Thank you, Judge. We do stipulate as to the factual basis, venue, and identification. Would ask the court to follow the state's recommendation.
Mr. Turner, it's my understanding that in case 22 CR 005035E, you wish to plead guilty to criminal trespass. Is that correct?
That's correct.
Are you under the influence of any drugs or alcohol this morning?
I am.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Turner. Good luck to you, sir.
Judge, position number 46, Ricky Williams. Likewise, I submitted the plea paperwork late last night, Judge.
Okay. Good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can place your hand down. Thank you, sir. Ms. Falk.
Yes, Your Honor, and let me just get to that position really quickly. And this is Williams, correct?
Yes, Ricky Williams.
That is position 46. The state's recommendation on the one count of criminal trespass is 12 months, serve 34 days. That's going to be credit for time served from February 18th to March 5th of 2024. We are asking that the balance be suspended, but the condition is that the defendant shall stay away from all MARTA stations. That's contingent upon a permanent ban that was issued by MARTA as part of this case. That's all for the state, and the state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
Mr. Dodd.
Thank you, Judge. We do stipulate as far as venue, factual basis, and identity. We'd ask the court to follow the state's recommendation, Judge.
Mr. Williams, it's my understanding that in case 24 CR 000832, you wish to plead guilty to criminal trespass. Is that correct?
Yeah. Yeah.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yeah.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yeah.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Williams. You know you can't go back to MARTA. If you do, they're gonna arrest you again, okay?
All right.
All right. Good luck to you, sir.
Thank you, Judge. Colin White. Your Honor, position number 44 and 45. Colin White. I submitted the plea paperwork late last night, Judge.
Okay. Good morning, Mr. White. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir.
Thank you. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. All right. Yes, Ms. Falk.
Yes, Your Honor. On position 44, the state on the count of driving under the influence less safe, we are asking that count merge with count 2. Count 2, driving under the influence of alcohol per se. The state's recommendation is 12 months to serve 40 days. Credit for time served 20 days. That's going to be from May 29th to June 1st of 2023, and then February 19th to March 5th of 2024. The balance will be probated. We are requesting a $600 fine, 40 hours of community service, DUI risk reduction, a victim impact panel, and alcohol, drug, and evaluation and treatment. On count 3, the no proof of insurance, we are asking for 12 months probation, a $350 fine, and that will run concurrent with count 2. That will be a total of 12 months, probation, serve 40 days, credit for time served 20 days, balance probated, $950 in fines, 40 hours of community service, DUI risk reduction, victim impact panel, and alcohol drug evaluation and treatment. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea, and the state has nothing further.
Sadat,
Thank you, Judge. We do stipulate as far as factual basis, identity, and venue. We just asked the court to follow the state's recommendation as a negotiated plea, Judge.
Mr. White, it's my understanding that in case 22 CR 0085548H, you wish to plead guilty to DUI per se and no proof of insurance. Is that correct?
Sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Let's see, when you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay?
Sir.
All right, good luck to you, Mr. White.
And Your Honor, I did omit that on position 45, the state is tendering a null pros.
Very good. Thank you, Ms. Falk. Before we go on, do we have a Larry Clark on this calendar? I'm only asking because I see a lot of Larry Clark supporters. I did not see a Larry Clark on my calendar, and I want to make sure that these people are in the right courtroom. And
Is it on the
don't sit-
probation calendar by any chance? Because it's not on the regular calendar or the
Right.
on the add-on.
I looked on that calendar also, and I don't see anyone by that name.
Your Honor, Lawrence Clark was on last Thursday's probation calendar with a recommendation of time served, but they thought he was in DeKalb jail. Unbeknownst to everybody, he was actually in this building. So after court, I, at some point, I forget what day, interviewed him. He's okay with the time served recommendation to dispose of his case. And quite a few people were pulling for him because they were upset, or, well, it's the wrong word. They were
Okay.
about.
Thank you, Mr. McLean. I appreciate it. I now I see that he is. I just wanted to make sure that we had that they didn't sit through the wrong calendar. So thank you. We'll get to him.
Right,
Thank you,
that,
Mr.
that should
I
take
appreciate
2
it.
seconds today.
Okay, very good. Thank you.
But he's not on the calendar.
Yes, Your Honor, Judge Law wanted to hear that case on Thursday, but he's definitely not on the probation calendar.
Oh, he's not on the calendar.
Oh,
Well, I
he's
have
not.
him on.
We did an add-on today.
Okay, well, I don't want the man sitting in, if he's, I'm not sure what the case is about, but I don't want to. Good morning, Miss Allen. Can we get, can you be prepared when we get to him to proceed with
Oh,
this
yeah,
case today?
yeah. Yes,
Okay.
definitely.
Okay, very good. Let's just go ahead and do it today, because if the recommendation is going to be time served, I don't want him sitting in jail for 2 more days, okay? All right, thank you all. Who do we have next?
Your Honor, position number 31 and 32, Geronda Road. Your Honor, we're pleading him not guilty. I did want to be heard as far as the bonds, and if now is a good time, we can do it now. If the court rather wait until the end, that's fine too, Judge.
No, I'd rather go ahead and since he's there, let's see, do I need to arraign him also? Mr. Haddad?
We can waive arraignment, plead him not guilty.
Okay. As such, Mr. Rhodes, your case will be returned to the division judge, and you'll get notification of your next hearing date. Let's see, who do we have on from pretrial this morning? Ms. Tyson, are you with me?
That's what
Yes,
position are we on, please?
Yes, what
Yes.
position are we? Who is this?
Oh, we're on position, I believe, 31 and 32.
Your Honor, I
we
apologize.
may-
I do not have a history for him, Your Honor. I'm not sure if Ms. Folk may have one.
And I do have one, but my Odyssey just clocked out, and so I have to go back into Odyssey. So if Your Honor could just give me a moment, or we could move on to another case until I can bring up my Odyssey.
I'll give you a moment since he's there.
Thank
And-
you.
Your Honor, well, Ms. Falk, I mean, I can let the court know, just from the Odyssey, Judge, he's got the misdemeanor that we're dealing with right now. He also has a 2010 SC 94420. This was a conviction for an aggravated assault back in 2011, Judge. And he had a probation violation connected to that.
Okay. Do you know what his current bond is?
Yes, Judge. So he has a $4,000 cash only bond. And Judge, the reason I believe is it is alleged that he missed court November 27th of 2023. And based on Odyssey, it looked like a jury trial calendar. And a bench warrant was issued and a $4,000 cash only bond was given. And if I can address that at the appropriate time, Judge.
Whose court was that in, Mr. Dodd?
It was in front of Judge Morrison, Judge.
Mr. Dodd, my normal practice is that if another division judge has issued a bond for missing court, I have the case returned to the division judge so that they can modify their bond or not themselves. Is there a reason that I should not follow my normal practice in this case?
No, Judge, other than to say that I normally don't handle these types of calendars, and I completely understand the court's position, and I'm not, I would
Okay.
change it, but I understand, Judge.
Okay.
Let me speak to Mr. Rhodes. In the
Okay.
back position.
If it had been an Orca bond or a bond that was from one of those calendars, I would address it, but I always send it back to the judge who issued the bond as far as if it's a division judge. So if you want to speak with him, I'm happy to give you that opportunity.
Thank you, Judge. And I think that's all I have for now. There's other folks in the courtroom that are represented by my.
Okay.
Judge.
Okay, you're fine, Mr. Haddad. So I'm sorry, Ms. Falk, you didn't have to assist me.
Well, of course, as soon as you guys finished talking, it came up. So, and not to add insult to injury, but he also does have a bench warrant on a 23 SC 189-826 case in the DA's office. So he's got kind of other things he's going to need to deal with as well.
Okay, thank you. Who can we take next?
Your Honor, can we revisit Mr. Rhodes?
Of course.
Your Honor, I had just a little bit of background. I spoke to Mr. Rhodes yesterday and I communicated the recommendation to him. And that's when the issue of the cash only bond came up. In any event, after speaking to him now, Judge, I believe he's ready to resolve by a plea. I explained to him that the state's recommendation, assuming that the court follows the recommendation, he will not be released today. He's got until the end of this month to complete. I explained that to him, but other than that, their standard battery type recommendation, Judge. So having said that, we're ready for a plea.
Okay, and just so that I don't know if you heard, but I want to make sure that you did, Mr. Haddad. Ms. Falk says that he also has a pending bench warrant for a felony charge. So if this plea is going to affect that felony charge, I'm not sure, but I just wanted you both to that I know that he's taking that into consideration when he's taking this plea.
Ms. Falk, can I ask which case? Because it looks like he had a probation violation that was resolved last year.
So the case that it's still showing in case manager as there is a bench warrant is 23 SC 189-826. I will say on the DA side, on the attorney manager side, it's showing bench warrant. Let's see. Let me go to the case manager side and just take a look. But the case manager side is not showing a bench warrant. So as I'm kind of digging into it, it was a re-indicted case. But I'm not sure if he bench warranted on the previous indictment. So I'm not sure, but I just wanted to warn you guys because sometimes it'll flag as they're about to be released. So you may want to just make sure before, he gets released that this is not going to hold him.
Judge, in light of the fact that he's not gonna be released today, what I'm gonna do, assuming we go through the plea, I'm gonna follow up and make sure that the felony, and thank you, Ms. Falk, for alerting me to this, that's been clear. And of course, if it's an issue, I'll get him in court, in Superior Court, to resolve that as well.
Okay, so you would like to take the plea on the simple battery today, is that what you're telling me?
Yes, Judge.
Okay, very good. Whenever y'all are ready,
Oh,
take
I'm ready.
your time, Mr. Haddad. If you need to speak with him further, I'm happy to give you that opportunity. If he's
All
ready,
right.
we
I think we're ready, Judge.
Okay, very good. Good morning, Mr. Rhodes. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Rhodes. Ms. Falk?
yes, Your Honor. The state's recommendation on this case is 12 months, probation, serve 90 days, credit for time served 19 days. That's going to be from June 11th to June 14th of 2022 and February 20th to March 5th of 2024. The balance will be probated. We are asking for no further contact with Angel Allen. We are removing the stay away provision, and I will explain briefly. And we are also requesting family violence intervention program and 40 hours of community service. We did have an opportunity to speak with Miss Angel Allen. I would like to sound for her, although she said she will not be on Zoom today due to work. She is in agreement with the plea offer. She states no stay away is needed because she has moved from that address and she does not wish to share her new address. That's all for the state, and we would like to ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We are also null prossing position 32 as a condition of this plea. That's all for the state.
If Ms. Allen is on the line and wishes to address the court, now is your opportunity to do so. Okay, yes, Mr. Haddad.
Judge, we do stipulate as far as venue, identity, and factual basis, Judge. And I'd ask the court to follow the state's recommendation as far as this case is concerned, Judge.
Mr. Rhodes, it's my understanding that in case 22 CR 003749E, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Good luck to you, Mr. Rhodes.
Thank you, Judge.
His probation, I'm sorry for interrupting. Was it non-reporting or does he remain on probation?
He's to remain on probation.
Thank
Who do we have next?
Position 14, Antonio Griffin.
Okay. And this is going to be a negotiated plea, is that right, Mr. McLean?
Yes, Your Honor.
Good morning, Mr. Griffin. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, sir. You can place your hand down. Good morning, Mr. Graham.
Good morning, Your Honor. The state's recommendation in this case, count one Sorry, it's only one count. 12 months, served 38 days, credit for time served 19 days. That's from February 16th, 2024 until today. Balance suspended, stay away from the MARTA in compliance with any and all current suspensions. We'll ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
For those purposes, we certainly do, and that is what we expected to hear, and we ask the court to accept the negotiated plea.
Mr. Griffin, it's my understanding that in case 24 CR 000802, you wish to plead guilty to one misdemeanor offense. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Good luck to you, Mr. Griffin.
Good to meet you. All right, take care.
Next, we have position number 13, Anthony Griffin.
Also a negotiated plea, Mr.
Correct.
McLean.
Yes, Your Honor, it is.
Good morning, Mr. Griffin. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? You swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Okay, you can place your hand down. Thank you, Mr. Griffin. Mr. Graham?
Yes, Your Honor. The state's recommendation in this case on count 1 of criminal trespass, 12 months, served 38 days, credit for time served 19 days. That's also from February 16, 2024 until today. Balance probated, no further contact with Mia, M-E-A-H, Constanzer, K-O-N-S-T-A-N-Z-E-R. A stay away from 266 11th Street in Atlanta. On count 2, criminal trespass, damage to property, 12-month probation concurrent with count 1. We would like to sound for the victim, Your Honor, Ms. Constanzer, and ask the defense to stipulate to venue, factual basis, identification for purposes of the plea.
Can we have that, just for clarification, before you go, Mr. McLean, Mr. Graham, can we have that balance suspended since there's nothing to be probated?
Oh, yes, Your Honor, no objection.
Okay, so, and if Ms. Constanza is on the line and wishes to address the court, now is your opportunity to do so. Okay, yes, Mr. McLean, I just wanted to clarify that it will be balance suspended so that he knows that.
Certainly, Your Honor. Thank you. For the purpose of the plea, we do stipulate.
Anything further?
Nothing further.
Mr. Griffin, it's my understanding that in case 24 CR 000801, you wish to plead guilty to criminal trespass and damage to property. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated, Mr. Griffin. Good luck to you, sir.
Well, traditionally, after about a week, you go to the clerk's office and get a certified copy of your disposition so that you can prove it to the world. The computer on it.
Next, we have position number 10, Xavier Gibson.
Let's see, this is a negotiated plea, Your Honor.
Good morning, Mr. Gibson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Mr. Graham?
Yes, Your Honor. The state's recommendation in this case is time served, 16 days, from February 16th through 17th of 2013, and then February 21st until today, 2024. And we'll ask the defense to stipulate to venue factual basis identification for purposes of the plea.
We do for those purposes. The only thing, we're putting up as a negotiated plea, it's this time served period offer. I did note that count 1 and count 2, as far as driving on a suspended license and driving without a license, can you do both at the same time? Does one merge with the other?
As far as the state's concerned, I think the answer is yes. If the license was suspended, and I'm assuming if he didn't have it on him, that may be the 2 charges.
Right, I mean, once it's suspended, are you required to have it on you? You're not supposed to be driving anyway, so I think it's basically one should merge with the other, but that's not, I'm not trying to break the negotiation.
Yeah, that's correct. Count 2 will merge with count 1.
Thank you.
So his license was suspended, is that right? Did he
That's
not
correct.
have a license or was it suspended? You know?
He's asking the state, not you.
I'm not sure, Your Honor. I believe it was suspended and he didn't have it, but I'll check.
Okay, no, I just want to make sure that he's pleading to the proper charge, and I believe that from what I just heard that he had a license, but it was suspended. Okay, so it's my understanding, Mr. McLean, that he's gonna plead to driving with a suspended license and no seatbelt.
Yes,
Is
Your
that
Honor.
right?
I believe seatbelt violations are a maximum of $15 fine, but are we simply going with a something else?
It's my understanding it's a time served plea. It's my
Right.
understanding that he'll be pleading to suspended license and no seatbelt. Is that correct, Mr. Graham, on your end?
Yes, Your Honor, that's correct.
Oh, okay, is that correct on your end, Mr. McLean?
Yes, Your Honor, he's
Okay.
grateful to be forgiven the $15.
All right, thank you. Okay, nothing further, Mr. Gibson. It's my understanding that in case 15 CR 001061, you wish to plead guilty to driving on a suspended license and no seatbelt. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Gibson. Good luck to you, sir.
Thank you.
Next, we have position number 6 and 7, Michael Dubo.
And this is going to be a non-negotiated plea?
Your Honor, yes, there was in the state's offer, there was a little bit of extra time requested, and Mr. DuBose would like the court to give him an extra break by not having extra days in jail.
Good morning, Mr. DuBose. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can place your hand down. Let's see. Let me first get his history. Ms. Tyson, do you have Mr. DuBose's history for me?
I don't have his history, Your Honor. I see it. I can't open them for some reason. I don't know why, but I have it. But if ASG Graham has it, maybe.
Okay, Mr. Graham, do you have Mr. DuBose's history?
Yes, Your Honor, I do. So it's got a couple of FTAs from 2020 or 2024, 2023, probation violation 2023, theft of lost mislaid property 2023. He's got theft by taking in August of 2022, another battery charge, June of 2022. That in that case, it's the same victim as here. Another 2022 family violence battery case out of DeKalb County with the same victim. 2023 criminal trespass. 2023 conviction for harassing phone calls and terroristic threats and acts. couple more FTAs, and that's kind of the 10-year history there.
Any of those convictions that you know of?
The last conviction, in 2022, a criminal trespass, in 2020, harassing phone calls and terroristic threats. And the one previous conviction to that is 2006 for aggravated assault, armed robbery, 2005 theft by receiving, 2004 obstruction, theft by taking, and 2001 criminal attempt are all convictions.
Okay,
Your Honor,
Thank-
in this case, May 12, 2022, law enforcement responded to a battery call at 6500 Connell Road in South Fulton. Upon arrival, they spoke with the victim, Mr. Shannon Boswell. He advised that his boyfriend, Michael DuBose, became upset with him, struck him with an open palm to the face, and stated that this was not the first time that Mr. DuBose has been physical with him. Our office has not been able to be in touch with Mr. Boswell since this incident. The warrant and the police report does state that Mr. Boswell wanted nothing more to do with Mr. DuBose and was ready just to kind of end the situation. The state's recommendation is 12 months to serve 60 days, credit for time served 15 days. That's from February 20th, 2024 until today. Balance probated, 8-week management, 8-week anger management, no further contact with Shannon Boswell. Stay away from Mr. Boswell's residence, which is 2350 Beecher Road Southwest in Atlanta. And Your Honor, the state is requesting that extra time based on those battery charges and it being the same victim in each of those cases.
Thank you, Mr. Graham. Mr. McLean?
Your Honor, my client is simply pointing out that the majority of the convictions he's had were some distance in the past. And in this situation, Your Honor, he is looking at the seriousness of the crime and he is taking it seriously and he is going to he's going to perform those conditions, let's see. But the stay away, the no contact, but he doesn't feel that he's going to be really learning anything more about his rehabilitation in the next 15 days being in jail as being out. He is remorseful and will take it seriously.
Based on the history, Mr. McLean, I will accept the state's recommendation if he wants to plead on this matter today.
We discussed that possibility. I believe he's going to stick with it. Let me double check. If I can put myself on mute for a moment. Thank you. Stick with it or not. Right. Your Honor, he is going to accept that and in 15 days, he'll get out there and do everything he needs to do.
Okay.
And Your Honor,
And Mr. Graham, go ahead.
yes, I will just, if we can sound for Mr. Boswell, Shannon Boswell, also to have the defense stipulate to venue factual basis identification for the purposes of the plea. And I did want to announce that for the FTA will be a null pros.
Thank you, Mr. Graham. If Mr. Shannon Boswell is on the line and wishes to address the court, now is your opportunity to do so. Okay, does not appear so. If nothing further, Mr. DuBose, it's my understanding that in case 22 CR 007259E, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea, Mr. DeBose. The sentence is 12 months to serve 60 days, credit for time served, 15 days, balance probated, 8 weeks anger management class, no further contact with Mr. Boswell, and stay away from the Beecher Road address. When you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner that you get the 8 weeks of anger management done, the sooner you won't be on reporting probation, okay? All right, very good. Good luck to you, sir.
Good to meet you.
And did you all see Ms. Lewis's request in the Ms. Lewis's request in the chat?
It was only sent to you, Judge.
Oh, okay. I guess you did. She's requesting that we do do we have Mr. Clark in the courtroom? Lawrence Clark?
We have him right here on the iPad.
Okay, all right. So are we ready on Mr. Clark's case? Yes, Ms. Allen?
Yes, Your Honor.
Thank you. Good morning, Mr. Clark. I'm Judge Eric Morrow. This is the
Morning.
probation revocation calendar that we're conducting by video. You agree to have your case heard by video?
Yes, yes, sir.
Okay, thank you. Yes, Ms. Allen.
Mr. Clark has been in custody since November 8th, 2023. He has failed to report to probation. He has failed to complete the shoplifting course. At this time, because he's been in custody so long, we're requesting that his case be time served.
Mr. McLean? You're on mute.
He agrees. Thank you.
Okay. Given the amount of time that you've been in custody, Mr. Clark, I will accept the probation's recommendation. As such, it'll be time served. Good luck to you, sir.
Thank you.
You're welcome.
Next, we have position number 4 and 5. Carol Brathwaite.
Your Honor, could we mute for just a moment?
Yeah, yes.
Yep. Ready, Your Honor. This is going to be not guilty and asking for a bond, Your Honor. He's a bond that he can make, which would be a signature bond. He has, I'll give the factors about him.
Okay, did he miss another judge's court date?
Let's see. He's been in continuous custody. Was there a court date?
Yes, he did. He missed it with Judge Besson.
Right.
There was a trial calendar. She put an FTA out on.
Okay, unless there's a reason that I should deviate from my normal practice, Mr. McLean, if another judge has issued a bond because of him missing a court date, I return it to that judge to seek modification. Is there a reason that I should deviate from my practice today?
Just the simplicity of the facts. He missed the court date. If it's been in the last 10 months, that was while he went to his holds in Cobb and Henry and took care of those matters, so he couldn't be in our court.
So he was in custody at the time?
What was the date?
The date was July the 25th of 2023.
Yes, on June the 10th of 2023, he went from, and he has proof of incarceration showing that he went from our jail at that point to the Cobb jail, and that preceded him going to the Henry jail. And he's taking care of all his business, but July 25th would have been about a month or so after he left our jail and he was taking care of his cop business at the time. He was still in custody.
Okay. Mr. Graham?
Thank you, Your Honor. I'm just trying to pull up the history here real quick. So I think there are
Given that he was in custody, is there any objection from the state of me reinstating his previous bond? If Mr. McLean provides you with that paperwork?
Yes, Your Honor, the state would want to see proof of incarceration before we make any kind of decision about agreeing to a bond. It's not that we don't believe Mr. McLean. However, I just want to make sure that he was in continuous custody during that time, and that normally comes with the paperwork.
This is what it looks like, proof of incarceration with the dates I mentioned.
Okay, can we get that to Mr. Graham or Ms. Falk, please?
Yes, Your Honor, somehow we can scan it in one of our copier machines in the medical records department if that machine is actually working. Otherwise, I'll try to photograph it with our methodology.
Okay, so what will you go ahead and do that, and once you get it, either Ms. Falk or Mr. Graham, if you'll just let the court know if you have any objection to me reinstating the bond.
Yes, Your Honor.
Okay, thank you.
Yeah, we'll send everything. I'll take it figure it out. Thank you. Don't give me a particularly this. I'll give this all back. Okay, here you go.
Next, we have position number 1, Travis Allen.
That's a negotiated plea, Your Honor.
Okay. Good morning, Mr. Allen. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Was that a yes, Mr. Allen?
Yes, it is.
Okay, thank you. Can you raise your right hand for me, please? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Is that a yes?
Sir.
Okay. Mr. Graham?
Yes, Your Honor. The state's recommendation in this case on count 1, theft by shoplifting, about 12 months, served 28 days, credit for time served 14 days, beginning February 21st, 2024 until today. Balance probated, stay away from the Publix at 950 West Peachtree Street Northwest in Atlanta. 40 hours community service, an anti-theft course. Count 2, criminal trespass, 12-month probation concurrent with count 1. And we'll ask for the defense to stipulate to venue factual basis identification for purposes of the plea.
We do so stipulate for the purposes of the plea. He and I have discussed the anti-theft course. He realizes it is his responsibility to find it, pay for it, take it, and prove it. And the 40 hours community service, we discussed what a 501c3 is. He's going to stay away from the Publix. And he would like to have the probation terminated or go to non-reporting if possible as soon as he completes his 2 special conditions.
Okay. Mr. Allen, it's my understanding that in case 24 CR 0000836, you wish to plead guilty to theft by shoplifting and criminal trespass. Is that correct?
Yes, as long as I can get out and go back to work, I do construction and you know what I'm saying, I take care of elderly women, you know what I'm saying?
Okay, thank you, Mr. Allen.
Hoping to get out this evening. I told him, you know, we're having computer problems and the jail's going to do its best to get him out as soon as possible. But we can't guarantee that it's going to be 12 hours.
Okay. Are you under the influence of any drugs or alcohol this morning?
No,
You've been represented by counsel. Are you satisfied with his representation?
yes, like,
Okay, you understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
yes, I do.
Has anyone forced you to plead guilty?
No.
Okay, I will accept the negotiated plea. Let's see, as soon as you complete the terms of the probation, it will terminate. So the sooner you get it done, the sooner you're not going to be on probation. Okay, Mr. Allen?
Yeah, so I can get out today.
You will get out as soon as if you don't have anything holding you, you'll get out as soon as the jail can release you, okay?
Yeah.
All right, good luck to you, sir.
All right. Now,
Okay.
good luck. Go back to that. Your Honor, while we're between cases, can I ask the probation department to put in chat the Sims and the Martin recommendation?
I can put it in the chat, but it was actually emailed with the other recommendations, but I can put it in the chat.
Right. I'll have to go to the window to get better reception. And
Okay, well, I'll put it in there right now.
thank you.
Who do we have next?
On the probation revocation calendar, position number 4, 4 and 5.
This is, here it comes in chat in just a second.
DeMarcus Sims.
This is Mr. Sims. Oh, it's not Sims?
Oh.
That's your name.
Martin
This is Mr. Martin then?
Position 2 and 3.
Right.
Okay, so this is Mr. Martin. Good morning, Mr. Martin. I'm Judge Eric Morrow. This is good morning, sir. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you, Mr. Martin. Let's see. Probation, are we ready?
I'm sorry, my apologies.
No, you're fine, Miss Allen. This is positions 3 and position 3, Mr. 2 and 3, Mr. Antoine Martin.
Okay, Mr. Martin was sentenced to
Go ahead. I'm sorry.
Okay, I'm sorry. Mr. Martin was sentenced to probation for the charge of criminal trespass, as well as complete anger management classes and pay probation supervision fees. As of today, the defendant has failed to provide our office with proof of completing the anger management classes. It's 242 days remaining on Mr. Martin's case. At this time, probation recommends for the defendant be allowed to continue on probation.
Claim.
I believe he agrees with that recommendation, Your Honor. That sounds logical. That will give him the chance to prove himself and to get it done.
Okay. Do we know what the problem is, Mr. McLean?
Your Honor, we do not. He has had some trouble with organization of life matters and life skills. I've talked to some of his relatives, but they're going to try to help him get it together.
Okay. So, Mr. Martin, I'm going to give you the opportunity to get this anger management done, but you're going to have to report as you're directed to, and you're going to have to start on the anger management. Otherwise, they're going to bring you right back here, and they will probably seek to revoke some of the time if you come back. So I urge you to go ahead on and get this done so you can get all this behind you. I will accept the probation's recommendation to continue you on probation so that you can complete the anger management. Good luck to you, Mr. Martin.
Okay, thank you, sir.
You're welcome.
Next, we have position number 2, 4 and 5. Sam DeMarcus.
What's the recommendation on Mr. Sims?
Revoke 10 days and close his case.
Okay, can we put that to the end of the calendar, Your Honor? I'd like to speak with him further.
Okay.
Thank you.
Next, we could go to medical or jail courts, iPhone.
We have position number 23, Mr. Jackson.
Okay. Is this, Deshaun Jackson?
Deshaun Jackson, yes.
Yes, sir.
Okay, he's position number 25 on my calendar.
25, yes. That's 25, yes.
Okay,
Yeah,
thank you. I just wanted to make sure that we had the right person. Ms. Vigiletti, good morning. What are we doing with Mr. Jackson this morning?
Mr. Jackson would like to enter a not guilty plea. He's actually entered one before in this court about this charge, but I would like to discuss bond.
Okay, let's see. So he's already been arraigned. Is that what you're telling me?
Yes, Judge. He was here on February 6th on the same charge. The case then moved to a trial court. In the past month, I've been told that the prosecution and defense couldn't get any discovery. And so they asked him to come back to SAP because they haven't made any progress on the case in the last month. But he did plead not guilty on February 6th here at the SAP court.
Okay, what is his current bond?
His bond is a $500 surety bond.
And may I have his history? Do you have the history, Ms. Tyson, or not?
I do, I have his, Your Honor.
Oh, okay,
Ada Recycles being in 2020 is a misdemeanor conviction out of Clayton County for battery, 2 counts of battery and criminal trespass. That's from 2021. Looks like he may have a possible pending case in Fulton County, carrying a weapon in a school safety zone, simple battery against a public school system employee, and cruelty to children in the 3rd degree. There's no disposition listed on the GCIC. Let's see, there's a second pending case. Arrest date was April 24th of 2023, and that's for battery, family violence, first offense, and possession of a Schedule I controlled substance. And it looks like his last arrest was also April 24th of 2023 for simple battery and looks like another count of battery, family violence. Nothing to add, Your Honor.
yes, Ms. Falk.
Yeah, so Your Honor, just to clarify on that 23 SC 1911007 case, let's see, we are showing that he disposed of that February 29th of 2024. He's currently under a first offender sentence for the carrying weapons within a school safety zone and family violence, and aggravated assault. He is currently on a 4-year serve 1 year, balance of 3 years to be served on probation. And he also pled to disrupting a public school on that case. So he is currently under sentence under that case. On the, let's see, the other case, which was, let me just go back to that, 23 CP 217980, the family violence battery in possession of a Schedule I, that is still open and active in the DA's office. What we have on this case is that, without going into too much detail, the defendant, while he was in jail, did commit the offense for which he is charged. I believe that given his history, which he is very quickly racking up, and he is now actually under sentence on one of these charges, I believe the $500 surety bond is more than sufficient for that offense. And we would ask that the bond remain in place. This incident did happen in the jail, and it did occur with one of the, let's see, it did occur in view of other individuals, and some of that footage was caught on the officer's body camera. So we would ask that the bond remain as set for $500, given the circumstances, given his open cases, and given the fact that he just recently pled to an offense, which would make him not entitled to the presumption of innocence on that case. Again, there's a pattern and a history here that seems to be increasing. That's all for the state.
Yes, Ms. Vigiletti?
Yes, Judge. Mr. Jackson has been in jail for over 320 days on his other charge. So this public indecency is my understanding from his felony and misdemeanor attorney that this public indecency is the only thing holding him because he has already done the jail time on the case that he recently took a plea to. I will say there has been mention that this incident was caught on camera. Like I said before, in the past month, neither the prosecution nor the defense has been able to get that video or any discovery in this case beyond the accusation. Without getting too deeply in the facts, Mr. Jackson told me a month ago, and he told me again yesterday, that this is a case of mistaken identity, that many people who are all dressed exactly the same in the jail were in the same area when this incident took place. I'll add that Mr. Jackson is on an ankle monitor. And so, you know, upon release, it's not like he is very likely to disappear. He is on a monitor.
And Your Honor, I would just like to say, and no disrespect to PD Vigiletti, but I think it's disingenuous at best to allege that we were not able to provide discovery as if the last month there were not catastrophic events going on with the systems that would have caused us to not be able to provide discovery in a timely fashion. This is not the state just willfully withholding discovery from the defense. There were a number of situations going on within the last month for which the court and everyone here is aware of that would have prevented the state from providing this discovery in a timely fashion.
I want to be very clear. I'm not saying that anyone did anything willfully or to cause harm, but I also don't think that the system being down should harm Mr. Jackson because he has been sitting for a month on this case when normally this is a type of case where discovery could be provided quickly and this could be disposed of quickly.
And again, he wasn't just sitting on this case. He was also sitting on an aggravated assault charge, which he just took a plea to last week on the 29th.
I understand, Ms. Falk, but that's no longer true. This is now the only thing that's holding him per his felony and misdemeanor attorneys. It's okay, Mr. Jackson, I've got you covered.
Okay, anything else from anyone?
I'll just add that Mr. Jackson does have a family. He has a wife, he has 3 kids. He's very much looking forward to getting home and getting a job and getting back on his feet so he can support his family. He is from Atlanta. When we spoke yesterday, he talked about wanting to engage in some reentry services. I'm actually sending a social worker up to talk to him about what he can do to get on and stay on the right path. In addition to him being on the ankle monitor, I don't see pretrial detention in this case ensuring he comes to court any more than Mr. Jackson's own disposition and the ankle monitor already would. Thank you, Judge.
Okay. Mr. Jackson, you have the right to remain silent. Anything you say can be used against you. So, given that this is the only thing holding you of no fault of anyone's, we've been having some difficulties in Fulton County. I believe everyone knows that. I want him to remain on the ankle monitor while he is out on this matter. I will give him a $5,000 signature bond through the jail. He's to have a social worker visit to assist with those things that Ms. Vigiletti, you said that he needs assistance with. I'll have him remain on that ankle monitor while he's out on this charge, even if it's not required on the other charges, but he's to remain on that ankle monitor and no drugs, alcohol, weapons while out on bond. Okay? Good luck to you, Mr. Jackson.
Probation number 1, Mr. Garrison.
Mr. Sims is now ready, also on probation. He's going to accept the concept they've laid out.
Okay, so
I'm sorry, the probation folks, JCS.
So let me
We're gonna do position 1, probation.
Okay, well, thank you. So this is Mr. Garrison. Can you hear me
Yes,
all right,
sir.
Mr. Garrison?
Yeah. Mr.
Okay.
Garrison is new to us. We didn't get a chance to talk to him yesterday, Your Honor.
Okay, so you need to talk to Mr. Garrison?
We do, but if they could put that in chat also, Your Honor. I'm gonna go over towards the window where it has some better reception so I can see the actual missive from the case.
Okay, so we'll have to have medical, Mr. McLean needs to speak with Mr. Garrison before his hearing, so
Right.
let's make that possible somehow.
Right. He's the add-on. Thank you. Yeah. So could we go ahead with Mr. Sims, Your Honor?
Where is Mr. Sims?
Right here.
Okay.
All right,
Yes,
Mr. Sims was required to report to probation for the charge of simple battery. He was required to complete domestic violence counseling. The defendant has failed to complete the domestic violence counseling. It is 10 days remaining on his probation case. At this time, probation recommends that this defendant balance be revoked 10 days and suspend balance.
McLean.
He accepts that notion, Your Honor. Thank you.
Okay, that'll be the order of the court. Good luck to you, Mr. Sims.
Thanks, sir.
So, Mr. McLean, are you gonna try to get in touch with medical?
Your Honor, I'm just gonna run up there.
Oh, okay.
Next, we have on the probation verification calendar, position number 6.
And who's representing Mr. Tankara?
Ms. Bridget.
Good morning, Mr. Tankara. I'm Judge Eric Morrow. This is the probation revocation calendar that we are conducting by video. Do you agree to have your case heard by video? Thank you. Ms. Allen?
The defendant was sentenced to probation for the charge of failure to obey traffic control device. He was required to pay a fine of $687.50. He has paid $51 towards his fine. At this time, probation recommends that this defendant case be time served.
Any objection, Ms. Vigiletti?
No, Judge.
All right, time served. Good luck to you, sir.
All right, thank you.
Good morning, Your Honor.
Good morning, Officer Milton. How are you today?
I have a question for
Yes.
the attorneys. Vanity Allman said that she did not speak to an attorney on yesterday. So if they need to speak with her, they can call over here or we can do a breakout.
Yes, ma'am, that is my client. I went to see her yesterday. She never came out to the booth. I assumed that there was some sort of miscommunication, so I do need to speak with her. Would you prefer I call you or get on Zoom?
Either way, what I'll do, I'll wait until you're finished with courtroom 1, 2, and then we can take care of ACDC.
Sounds great, thank you.
You're welcome.
Thank you, Milton.
You're welcome.
Next, Your Honor, is going to be position number 20, Mr. Keon Hendricks, position 20.
Okay. And this is going to be an arraignment and a bond modification request?
Yes, Judge.
Okay. Good morning, Mr. Hendricks. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Do I need to arraign him, Ms. Vigiletti, or are you going to file a waiver?
I can file a waiver.
Okay. As such, Mr. Hendricks, your case will be returned to a division judge and you'll get notification of your next hearing date. Ms. Tyson, do you have Mr. Hendricks's history for me?
Yes, Your Honor, I do. We have 11 arrest cycles beginning in 2019. There's a felony conviction out of Clayton County for aggravated assault, criminal trespass, and battery. Disposition date on that case is June 2022. Looks like he received 6 years probation on that case, so he's probably still on probation. We have another felony conviction out of Coweta County for fleeing or attempting to elude a police officer. DUI and driving without a valid license. Disposition date on that case is August of 2022. He received probation, 11 months, 27 days, and a 1-year confinement. We have a misdemeanor conviction out of Stevens County for criminal trespass, June of 2023. We have another felony conviction out of Clayton County for aggravated assault. Disposition date on that is June of 2022. Yes, he was sentenced to 6 years probation on that case. We have another misdemeanor conviction for theft by shoplifting. He took a no-low plea on that case in Gwinnett County, June of 2023. And it looks like he has an FTA from 2024, 2023, 2022, and 2021, which his last arrest was one of those FTAs in DeKalb County, January 22nd of 2024. Nothing to add, Your Honor.
Okay, it's my understanding from Ms. Lewis that I issued Mr. Hendricks a $2,000 surety bond on February 19th. Mr. Graham?
Thank you, Your Honor. Yeah, the state's position, we would object to any reduction in the bond amount. Based on the history, I think it's still reasonable.
Ms. Vigiletti?
Yes, Judge, I spoke with Mr. Hendricks yesterday and again today, and he has the money to pay bond. He's financially responsible. He works at TME Productions. He does stage setup work. What he does not have is anybody's phone number memorized, as many people his age do not. He does not know the phone number of anybody who will sign the bond for him. And so I'm asking today if you would consider a signature bond with the understanding that Mr. Hendricks has managed to keep his job to date, but may not be able to keep his job if he's in much longer. He's from Atlanta. He lives with some friends, the friends of his that would be willing to bond him out. He is telling me this incident, without getting too deep into the facts, is a misunderstanding, and that this bartender that he's accused of committing a battery against hit him first based on some misunderstanding of a chaotic incident. And he really believes that once footage is produced, that he'll not be convicted of this case. I would hate to see him plead to this just to get out of jail and keep his job. So just asking for a signature bond today, Judge.
I'm not going to issue him a signature bond. I don't see any changed circumstances. I remember Mr. Hendricks from the SEA calendar. The alleged victim was also there. Also remember his reaction after I issued him the bond. And I also find it, given his history and given the fact that you say that he can, I'm sure that if he can give you the names of some people, those people, that maybe you can track him down for him to come and help him with his bond. But as far as today goes, I'm not going to modify that bond. All right. Good luck to you, Mr. Hendricks. Who do we have next?
Next, we're going to go back to the probation revocation calendar, 7 and 8, Mr. Antonio Tutman.
Okay. Good morning, Mr. Tutman. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video? Yes, Ms. Allen.
Mr. Tutman was sentenced to probation for giving false name and date of birth. He was required to report to probation and complete 30 hours of community service. At this time, the defendant has failed to provide documentation of those 30 hours of community service, and he has failed to pay his probation supervision fees. At this time, probation will recommend that his case be time served.
Any objection?
No, Judge.
Okay, time served. Good luck to you, Mr. Tutman.
Next, Your Honor, we're going to go to position 28, Mr. Christian Morgan. Position
Okay. And what are we doing with Mr. Morgan this morning?
Yes, Your Honor, Mr. Morgan, would like to enter a not guilty plea, but did not want to waive any of his rights this morning.
Okay. Good morning, Mr. Morgan. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you. Mr. Morgan, you've been charged in case 24 CR 0000808 with terroristic threats and acts. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Vigiletti?
Yes, Judge.
How do you plead, Mr. Morgan? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to a division judge and you'll get notification of your next hearing date. Good luck to you, sir.
I don't think he's gonna like that. I don't think he's gonna want you to do that. I understand, but there is nothing more that this judge is gonna do for you.
I mean, anytime I get out, the police can just lock me up for no reason. Just stop and I get one more.
Sorry, we
Next, we're gonna go to position number 37 and 38, Mr. Mark Simmons.
And this will be a non-negotiated plea.
Yes, Judge.
Good morning, Mr. Simmons. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir, good morning, Judge.
Thank you. And was that a yes for me?
Yes.
Okay, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Let's see. Ms. Tyson, do you have Mr. Simmons's history for me?
Yes. Of 28 arrest cycles, the state of Georgia began 2001, has three felony convictions outside of the 10-year period. It's been the last 10 years. Looks like he has a misdemeanor conviction out of Habersham County for driving while license suspended or revoked. We have a theft by taking out of Gwinnett County from 2020, took a NOLO plea on that case. He has 5 violations of probation, another misdemeanor conviction out of Dunwoody from 2023 for driving while license suspended or revoked. Looks like he may have a pending case for theft by receiving stolen property out of Fulton County. The arrest date on that case was April 27th of 2023, and there's no disposition listed on the GCIC. Looks like he has an FTA from 2024, which was also his last arrest. And he has 24 cycles out of Florida. His last arrest was in 2002, so everything's outside of the 10-year period. And it looks like GCIC indicates a active warrant out of Doraville. That warrant was signed December 5th, 2023 for a failure to appear. Nothing to add, Your Honor.
Okay. Ms. Vigiletti, given that it's a time served plea, what is contested?
Yes, Tiana Fleming, who is here today, is Mr. Simmons' wife. They've been together for 17 years. They have a 12-year-old son together. You just heard Mr. Simmons' history. There is not family violence history. They have not had an incident since. Both Ms. Fleming and Mr. Simmons describe this time in their marriage as a low point in their lives. They had just fallen on some significant financial hardship. In light of all of that, they would like contact with one another. They are a family. They're still together. They've been together 17 years.
Your Honor, state will modify to no further violent contact.
Okay. Anything, would you like to put the recommendation on the record?
Yes, Your Honor. The state's recommendation is 12 months serve, and we're going to modify this to 110 days, credit for time served 55 days, just so that he gets the full credit for time served. That time served was from April 28th to May 5th of 2023, and January 19th to March 5th of 2024. We are agreeable to no further violent contact with Tiana Fleming. There is no stay away as a part of that plea, family violence intervention program, 40 hours of community service, and no firearms. We would like to sound for Ms. Tiana Fleming, and we do ask that the defense stipulate to venue factual basis and identification for the purposes of the plea.
We do.
Okay, and I see Ms. Fleming is on. Ms. Fleming, if you would like to address the court, now is your opportunity to do so. I'll have to have you unmute yourself. Raise your right hand for me. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor. Good morning.
Okay. Good morning, ma'am. What would you like? And it's my understanding that you would like contact with your husband, Mr. Simmons. Is that correct?
Yes, absolutely. Of course, we've been together for a very long time. We have a 12-year-old son. At the time this incident occurred, we were going through an eviction process. So of course we were having, some financial troubles. And of course that brings, arguments and different things like that. And that's exactly what occurred this day. One of the neighbors, of course, it was kind of early in the morning, heard it and called in, and the police came. They took a report. At the time, my husband had left, and so he wasn't there. The police officer called him and just told him they wanted to hear his side of the story. The police officer left. We honestly thought it was over with until he had another situation where he was approached by the police, and then when they ran his name, that he had a warrant for this particular case. So we've been trying to get this resolved ever since it happened. Like I said, the day that it happened, we thought it was done and over with. It wasn't until months later that he was, caught up with this situation. It's been a year now, and we've still been just trying to get it resolved. We've been together this entire time, just trying to, figure out life like many other couples. I do just want to add that I don't have many instances in court, so I don't have a lot of experience with it, but just listening to the other court cases that involve this type of case, I do see that this is kind of like a blanket type of thing that they're given to most people with the no contact, but we're certainly not wishing that. We don't have any previous history of these things, and we're just trying to move forward.
Okay, so the state is amenable to there being no further violent contact, Ms. Fleming. So that was what the court will order, given what you're telling me this morning. That we appreciate you being here this morning. Sir. Thank you. So now,
thank you so much.
You're welcome. Thank you, ma'am. Ms. Vigiletti, so now this is going to be a negotiated plea. Is that correct?
Yes, Judge.
Okay. Anything further?
No, Your Honor.
Okay. Mr. Simmons, it's my understanding that in case 23 CR 002639Y, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
No, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated. Mr. Simmons, let's see, as soon as you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get the terms done, the sooner you won't be on reporting probation, okay?
Thank you, Judge.
All right.
Thank you.
All right. Good luck to you, Mr. Simmons. You also, Ms. Fleming.
Thank you, Your Honor.
And Your
Thank
Honor,
you so much.
the state has agreed to null pros position 38 as a part of this plea. I will just advise that Mr. Simmons does have 2 foreign county holds, as well as an open felony case that he will remain in custody on.
Okay. Thank you, Ms. Falk. Who do we have next?
Next, we have position number 40, Mr. Stevens.
Okay. And this is going to be a negotiated plea?
It is, Judge. I submitted the paperwork late last night.
Okay. Yes, can you hear me okay, Mr. Stevens?
Yes, sir. Yes, sir.
Okay. Good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, thank you. Can you raise your right hand for me?
Yes, sir.
Okay, do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Okay, thank you, Mr. Stevens. You can put your hand down.
Yes, sir.
Okay. Ms. Falk?
Yes, Your Honor. The state's recommendation on this case is 12 months, serve 206 days. We are giving credit for time served for 206 days from August 9th to March 5th, 2024. We are asking that to be day for day and not 2 for 1. I will explain why. Balance probated. We are requesting $400 in restitution, no further violent contact with Rashunda Coffin, stay away from 307 University Avenue. And so the reason we're asking for day is because of that $400 in restitution, and we are agreeable to doing non-reporting or just terminating once that restitution is paid.
Ms. Haddad?
Judge, I would ask the court to terminate probation once the restitution is paid. My client was initially arrested for a felony, involves his sister. It was reduced to a misdemeanor, of course. Other than that, we do stipulate to venue, factual basis, and identity.
And Your Honor, we would also like to sound for Rashunda Coffin in case she is present today.
Okay, Ms. Rashunda Coffin is present and wishes to address the court. Now is your opportunity to do so. Doesn't appear so. Mr. Stevens, it's my understanding that in case 24 CR 0000930, you wish to plead guilty to criminal trespass and damage to property. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Mr. Stevens, as soon as you pay the $400 back, you won't be on probation. So the sooner you get that done, the sooner I'm going to terminate that probation, okay?
Yes, sir. Thank you. So will I be able to go home whenever?
If you don't have any holes, you will be released as soon as the jail can release you, okay?
Yes, sir. I don't have any holes. All right.
All right. Good luck to you, Mr. Stevens.
All right. Thank you.
Excuse
You're
me,
welcome.
Judge. Ms. Falk,
Yes.
will you email me the restitution contact information?
I can.
Yeah, I need the individual name, contact, and phone number so probation will know, and I can write it on the form.
Yes, ma'am.
I appreciate that. Thank you.
Your Honor, can you put Mr. Mike McLean in medical in the breakout, please?
Okay.
And
So,
then we're gonna go to position number 17.
okay, thank you. And this is Mr. Harris.
Yes, Judge.
Good morning, Mr. Harris. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Harris? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Mr. Graham?
No, yes, Your Honor. The state's recommendation in this case, count 1, theft by shoplifting, 12 months, served 30 days. Credit for time served 15 days. That's beginning February 20th, 2024 until today. Balance probated, $500 fine, anti-theft course. Stay away from the incident location. Count 2, willful obstruction of law enforcement officer, 12 months probation concurrent with count 1. A $300 fine, and 40 hours of community service.
And there's no objection to a no-load?
No objection, Your Honor.
Ms. Biglietti?
Yes, Judge, Mr. Harris, I talked to him about this incident yesterday. He was homeless at the time. He is now staying with his sister, has a stable address and a phone number. He's been a cook in the past and tends to go back to cooking. I don't suspect that we'll have any incidents in the future with Mr. Harris. He would like to enter a NOLO plea today because he is on probation in Clayton County. We did talk about the limitations of a NOLO plea, also that it can only be entered once every 5 years, and he would like to use it to hopefully give him the best chance of his probation not being impacted.
Okay. Ms. Tyson, did you have something for me?
He just took a NOLO plea on a theft by shoplifting February 5th of 2024 in Atlanta.
I was going to say the same, Your Honor, and so he's not eligible.
Okay, so would he still like to go with a guilty plea?
If you could just give me one moment.
Okay, yeah, take your time.
Okay, Judge, we're ready to proceed with the
Okay, Mr. Harris, it's my understanding that in case 24 CR 0000846, you wish to plead guilty to theft by shoplifting and willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I'm sorry. Okay, we'll talk about it in a second. Just answer the judge's question.
Say no. Can you repeat that, sir, please?
Okay, you understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right. You understand that?
Yes, sir.
Has anybody forced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Mr. Harris, let's see. When you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't have to report to probation and pay those fees, okay?
And Judge, if I may ask the question Mr. Harris just asked me, because he is job seeking, he's unemployed, he'll be job seeking, is if the court would consider waiving the first couple of months of his fines.
You're asking for a waiver of some of the probation fees?
Fees, I'm sorry.
Okay, all right. I'll waive 2 months of probation fees to help him get and stay on his feet, okay?
Thank you, Judge.
That should give him enough time to get a job. All right. Good luck to you, Mr. Harris.
All right, thank you, sir.
You're welcome.
It's gonna be position number 8, Mr. Paul Edwards.
What are we doing with Mr. Edwards this morning?
Mr. Edwards is prepared to take the plea as negotiated, Judge.
Okay, good morning.
I apologize. I did want to ask, just because Mr. Edwards is on Social Security income, if you'd be willing to waive his probation fees. But aside from that, he's prepared to take the plea as negotiated.
Okay, good morning, Mr. Edwards. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you, Mr. Edwards. Mr. Graham?
Yes, thank you, Your Honor. The state's recommendation in this case on count 1, 12 months served 24 days, credit for time served 12 days. That's beginning February 23rd, 2024 until today. Balance probated, ADET, risk reduction course, $300 fine, 40 hours community service, and one VIP. On count 2, 12 months probation concurrent with count 1. Count 3, 12 months probation, $500 fine, a 6-month suspended license. Count 4, 12 months probation concurrent with count 1. Count 5, 12 months probation concurrent with count 1. And count 6, $200 fine, for a total of 12 months, served 24 days, credit for time served 12 days, balance probated, ADET, R&R, 40 hours community service, 1 VIP, and fines totaling $1,000.
Yes, Ms. Vigilante.
Yes, Judge, Mr. Edwards, we did speak this morning. Like I said, he is on Social Security income. His income is less than $400 a month. So if there's any way we could assist him with his probation fees, that would be greatly appreciated. But aside from that, we've discussed all the terms of the plea and he's prepared to move forward.
Okay, let's see, I would consider, if there's no objection from the state, converting some of the fines into community service, if that would help him. To do more community service in lieu of the fines.
Yes, Judge, we would greatly appreciate that.
Okay, so he's got $1,000 in fines. I can convert that to 100 hours of community service, so it would be 140 hours of community service.
And Your Honor, if I may, the fines are statutory, so the state will object to any reduction in that.
Okay, I don't want to set him up to fail, so I am going to, Ms. Lewis, did you have something?
Yeah, I was just gonna ask for the breakdown of the fines, if it's gonna be, just the fines on the count 3 and count 6, are you converting, or are you converting, the 300 and the 500 and the 200?
Whole $1,000, all of it.
So that
So-
means 30 hours of community service on count, because I think it's 10 hours.
Right, so whatever fine would be, is the $300 fine will be 30 hours. The $500 fine will be 50 hours. The $200 fine will be 20 hours.
Okay.
Okay? And then there's the other 40 hours of community service that goes along with count 1. So
Okay.
total of 140 hours of community service.
Got it.
Okay, thank you,
Thank
Ms.
you.
Lewis.
Mhm.
So I can help him out that way, Ms. Vigilante, okay? And as soon as he completes the terms, I'll have it go to a non-reporting status. So that the sooner he gets it done, the sooner that he won't have to report, the sooner that he won't have to pay the $49 a month. So that'll give him incentive to go ahead and get all this done. Okay? All right, so if nothing further, Mr. Edwards, it's my understanding that in case 21 CR 006655Y, you wish to plead guilty to driving under the influence of alcohol, less safe, reckless driving, driving while your license was suspended or revoked, failure to maintain lane, failure to yield right-of-way to an emergency vehicle, and possession of an open alcohol container. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I understand.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the plea as negotiated with the modifications of the fines to community service. As soon as you complete the terms, it'll go to a non-reporting status. Good luck to you, Mr. Edwards.
Can we go back to position?
Okay,
We have position number 9, Mr. Ricardo Gale.
okay,
Bradley?
In your honor, if I may, on position number 9 will be a null pros. I will send that paperwork over ASAP.
All right, so, is this, can you hear me, Mr. Gale? Yes, the state is now processing the charge against you,
Oh, I see.
okay? They're dismissing it, so you have a good day.
We're going back to 4 and 5. Mr. McLean. We're going back to position 4 and 5.
Okay,
I remember position 1, Garrett. Probation number 1, I'm sorry.
thank you.
We're on position 1 on probation. That's usually.
Okay, so Mr. Garrison, where's Mr. Garrison?
Medical.
Okay, can you hear me, Mr. Garrison?
Yeah, yes, sir.
Okay, yes, good morning, sir. This is the probation revocation calendar that we're doing by video. Is that okay with you?
Yes, sir.
Okay, thank you. Miss Allen?
Mr. Garrison was sentenced to probation for the charge of simple battery. He was required to complete a 12-week anger management course. As of today, the defendant has failed to provide proof of that anger management course. Because of the time frame remaining on the case, probation asks that his case be time served.
Mr. McLean, any objection?
No objection, Your Honor.
All right, I'll accept the probation's recommendation. Time served. Good luck to you, Mr. Garrison.
In front of us, we have position 4 and 5. Carol Bradley.
So did the state get what they needed to get on this?
No, Your Honor, we haven't been able to send that yet. If it's okay with the state, I'm just going to come over to the Carnes building and provide them a copy by borrowing the clerk's copying machine and giving them a hard copy.
Is it at all possible we could just take a picture of it and just send it to my phone?
Yes, I'll go back to the window where the reception is halfway decent. I'll do a photographic text, a direct message DM to your cell phone.
I just think that would be easier since we're trying to get this resolved before the close of calendar.
Sure.
Okay,
Okay.
thank you.
And tell me while we have Mr. Braithwaite there, what was the previous bond and the conditions? Just so that Mr. McLean has them if you all agree. Do we have that?
Yes, Your Honor, I can pull that up. Let's see. Okay, so. See, and this is the simple battery family violence, correct?
Yes.
Okay, so it says defendant made new bond.
He believes
Actually,
originally it was a $4,000 OR bond and then later it was changed and he made bond again.
right, it was changed because of an FTA, but I'm not sure what it was changed to at that point.
We think it was changed to a security bond, a surety bond in the amount of $4,000 also.
Okay. I'm showing a $3,000 surety bond, so,
Oh,
and
we
you may have said that, but
No,
yeah.
he thought it was also 4, but we stand corrected. That's fine.
Yeah, and so yeah, his bond receipt is showing it was a $3,000 surety bond on this, Your Honor, for the failure to appear back in 2023.
Okay, so what are you requesting, Mr. McLean?
I will shoot a direct message photograph to the cell phone, and they'll be able to print that out if they.
No, I understand that. I'm talking about the bond modification.
Oh, just to reinstate the bond that he made last time.
And Your Honor, we would ask for a condition of no further contact with Joya McLaurin, McLaurine, and we would like to sound for her in case she's here.
Right, and there's no reason for them to be in contact, so that's fine.
Okay.
Okay, if Ms. McLaren is with me and wishes to address the court, now is your opportunity. Okay, so once you get that, Ms. Falk, if you'll just let the court know that there's no objection and the bond will be reinstated with the no further contact provision.
Will do, Your Honor.
Okay, thank you.
I'll give the file back to you. Sit down. Wait.
Right, so is there anyone we can take now?
Position number 21 through 24, Jermaine Ivy.
This is the main count.
Have you been able to speak with Mr. Ivy?
Yes, Judge, I just met Mr. Ivy this morning, and I have sort of an unusual announcement. Mr. Ivy informed me that he's been incarcerated in Cherokee County since November 9th. So I have been working on getting proof of that, but just since we've been here in court, he is currently being held on 2 failures to appear on January 4th. And because there is proof of incarceration, Judge, I am hoping I can get that proof today, and I'm asking the court to null cross those failure to appear charges.
Okay, and as far as the other main charges go,
Yes, Judge. I believe that the prosecutors are attempting to have the battery family violence transferred to the DA's office. I'm not sure if that is complete yet. The willful obstruction charge, Mr. Ivy is not prepared to plead to, so I guess he'd be entering a not guilty plea.
okay, Mr. Graham, let's see, have you all submitted this for DA transfer?
Yes, Your Honor, it has been, we did request the transfer on the battery family violence. We're just waiting for a response. DA's
Okay.
office.
When do you think that you'll have a response? By Thursday? I want to take care of everything at one time, Ms. Vigiletti, to give you the opportunity to get what you need together. So if I can place him on Thursday's calendar, that'll give us a little bit more time to see if the DA is going to accept it, and it'll give you some time to get what you need to get to present to the court.
That would be very helpful.
Would that work?
Yes, thank you.
Okay, is that all right with you, Mr. Graham?
If we could do Tuesday, I think that may be a bit more reasonable.
So my concern, Judge, is that it appears that it's just the failure to appear charges that are holding him. So if we could get those dropped, he would be released from jail. He is bonded out on the underlying charges.
Okay, let's start off with Thursday, Mr. Graham. And if you haven't heard back from the DA's office by that time, then petition the court for more time at that time. But if you do, then we can move everything forward. Okay, so Mr. Ivy, your case is going to be reset until 3/7. Okay.
Yes, sir.
Okay, who else can we take?
In medical, Judge, I think that is position number 39, Scribe.
Okay, and that's going to be a negotiated plea.
It is, Judge.
Okay. Can you hear me okay, medical, Mr.
Yes,
Grimes?
we can hear you. We just had a lot of background noise.
Okay, yes, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Yes?
Yes,
Okay, thank you. You have to be verbal for me, okay?
yes,
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes.
Okay, you can place your hand down. Thank you. Yes, Ms. Falk.
Your Honor, just to ask, Mr. Haddad, is is the defendant also pleading to 24 CR 00813 as well?
All
Or
right.
sorry, I'm sorry, not 24 00813. Is the defendant also pleading to the criminal trespass that we added on to the calendar?
Yes, that's fine.
Okay, I just wanted to wait. I think the defendant is trying to say something.
So, Mr. Scrine, what I want to let you know is that you have another criminal trespass. Stay away from the Burger King. It's going to be run concurrent, same time, okay?
Yes. Is it possible that I can get out today because I got a funeral I gotta go to?
Well, as I explained, the recommendation is not a time served sentence. Your release date will be around March 31st. So other than that, Judge, we're ready. It's something that I've discussed with Brian yesterday at length.
Okay, so Ms. Falk, you mentioned an add-on. Do we have that on an add-on calendar?
Let me just double check on our add-on calendar, Your Honor.
I have one, but I don't see,
I'm just trying to find out, did you do an add-on to this charge, Ms. Walk? Did you say
It was one where I requested, no, it wasn't an add-on charge. It actually is another open case, and it's one where I did request that it be put on the add-on calendar. The case number, let me just get that for the court and for everyone involved, is okay. Oh, actually, hold on. I may have that may be one. Let me just double check something. Let's see. Actually, my apologies. Mr. Scrines, that second case, it was an open criminal trespass where there was a NOD filed on it. So actually the state does not need to go forward on that add-on. I just needed to double check something and kind of refresh my recollection on that. So we are just moving forward on the battery.
Thank you.
okay.
Thank you. So on this case, Your Honor, the state's recommendation is 12 months probation, served 90 days, credit for time served 19 days. That's going to be from February 16th of 2024 to March 5th of 2024. Stay away from the Days Inn located at 2451 Old National Highway. No further contact with Manarajan Matu, and 8 weeks of anger management. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state, and we would like to sound from Mr. Manarajan Matu in case he is present. Thank you, Your Honor.
If Mr. Matu is present and wishes to address the court, now is your opportunity to do so. Doesn't appear so.
And Your Honor.
Oh, go ahead, Ms. Falk.
We did speak to the victim. He will not be on, he did state he will not be on Zoom due to work, and he does agree with the plea offer.
Mr. Haddad, it appears that your client might need to speak with you. I'm not sure.
Judge, just to first, I will stipulate to what we need to stipulate. Mr. Scrine, I'm not sure you need to speak to me separately, because the recommendation, as I explained to you several times yesterday, you're not getting out today. So you're getting out at the end of this month. You want to take the plea or not? It's just.
So if I take the plea, what? If I take the plea, if I take this plea today, what? If I don't take the plea, what will happen? I'm still gonna be locked up.
That's right.
I'll take the release date.
All right. So I think, Judge, I think what the issue is that if we enters a plea of not guilty, it's gonna take a while to go in front of a division judge, so.
Okay.
He wanted to resolve it yesterday when we spoke, kept asking for a time served. I explained to him several times that the recommendation from the state is not a time served sentence, that based on my calculation, the release date should be March 30th or March 31st, Judge, of this month.
But if it's jail is 2-for-1, that doesn't, I mean, and I already served 19 days, there's gonna be more, there's gonna be 45 days over. There's gonna be more days I don't spend, right?
No, the recommendation is that calculates the 2-for-1.
You'll have 26 more days to serve.
Oh, I'll take it.
Okay, anything further, Mr. Haddad?
No, Judge.
All right, and before I take the plea, it's Giovanni Scrine. How would you like me to address you, Mr. or Miss?
Me,
How?
Mr.
Mr.? Okay. All right, Mr. Scrine. It's my understanding that in case 24 CR 000813, you wish to plead guilty to battery, is that correct?
Yes, I do.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I do. Yes, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated. Good luck to you, Mr. Scrine.
So when will my release date be?
I can't tell you, but Mr. Haddad may be able to get you a better understanding of what that release date will be, okay?
Thank you, sir. Okay, is it possible? Can I call him? Can he tell me? I just want to be reassured when my release date.
I'll follow up with you, Scrine.
Okay, thank you.
Thank you.
Right.
Judge, I didn't hear anything regarding about the condition of his probation at the end. Was his probation terminated, non-reporting, or remain on probation?
I'll have it go to a non-reporting status once he completes the terms.
Thank you, Judge.
Okay, who do we have next?
Next, we have on the add-on calendar, position number 4, Mr. Sims.
Your Honor, the state also did receive the proof of incarceration email from pictures from Mr. McLean on Harrell Braithwaite, so we do not object to the lifting of the bench warrant, the case being reset for a further notice date on his outstanding offense.
Thank you, Ms. Falk.
Since he's in jail, so that means Mr. PD's gonna have to do an order to set aside the FTA and reinstate the original bond on it. That's what the order needs to indicate.
When Mr. McLean comes back in, we'll remind him.
Okay.
Okay. And this is Mr. Sims.
Yes.
Let's see, what are we doing with Mr. Sims today?
That is a negotiated plea, Judge. I submitted the paperwork
Okay.
last night.
Good morning, Mr. Sims. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can place your hand down. Thank you, Mr. Sims. Ms. Falk?
Yes, Your Honor. Sorry, just trying to get to the right calendar of many. All right, on the charge of disorderly conduct, the state's recommendation is 12 months probation, 120 days credit for time served, 35 days. Stay away from 841 Oak Street, which is the Little Caesars. No further contact with Cheryl Poole, that is SHERLYE POOLE. possess no weapons, and 12 weeks of anger management. We have had an opportunity to speak with Ms. Poole. She stated she will not be on the Zoom due to work, and she does agree with the plea recommendation. I would like to, out of an abundance of caution, just sound for Ms. Poole in case she was able to make it today.
If Ms. Poole is on the line and wishes to address the court, now is your opportunity to do so.
I was sent by the West End Taco Bell.
Hold on, Mr. Sims, Mr. Sims, let me just say you have a right to remain silent. Anything you say can be used against you. If you want me to allow you to speak with your counsel, I'm happy to do that, okay? All right, Mr. Haddad?
Your Honor, we stipulate, Judge, ask the court to follow the state's recommendation.
Mr. Sims, it's my understanding that in case 24 CR 000564, you wish to plead guilty to disorderly conduct. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol this morning?
Don't drink or smoke.
You've been represented by counsel. Are you satisfied with his representation?
Yeah.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right? You understand that?
Yeah.
Has anyone forced you to plead guilty?
Yeah.
Okay, so then listen to my question. Did somebody force you to plead guilty this morning?
Yeah. Did anybody force you to plead guilty? No. I was sent by the Taco Bell and they came talking to me.
Hold on, Mr. Sims. So I just want to make sure that you're pleading guilty on your own free will. Is that the case?
Yeah. Nobody made you plead guilty, right? No.
Okay, I'll accept the plea as negotiated. And once he completes the terms, it'll go to a non-reporting status.
Thank you, Judge.
All right, good luck to you, Mr. Sims.
Judge, I have one question, if I may.
Okay.
On position 34, Horace Road. I don't know where he's at, Judge. That's the one that I still need to speak to him. I just want to let the court know.
Okay, who do we have there with you? Is Nora still in the courtroom?
Do you know where 30 road is?
Says he's on 3 South.
Okay, is he gonna be on video or you don't? Okay.
In court, we have position number 15 and 16, Bradford Harper.
Wanted to give us back the break points.
Mr. McLean.
Yes, Your Honor.
I'm being told that I think we have your client 15 and 16. Are we ready to proceed with Bradford Harper?
We are. We are.
Okay. Who? Now I don't see them anymore. Who was telling me that we have Mr. Harper?
Yes. He's ready, Your Honor. He's right here.
Oh, okay. Very good. Good morning, Mr. Harper. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me?
Yes.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, Mr. Harper. Yes, Mr. Graham.
Thank you, Your Honor. The state's recommendation here on count 2, 12-month probation served 172 days, credit for time served 86 days. That includes a period from September 25th through 26th, 2023, and December 13th through February 27th, 2024. I'll double check that. Stay away from all MARTA, 40 hours community service, 8-week anger management. Count 1, 12 months probation concurrent with count 2. Count 3, 12 months probation concurrent with count 2. Count 4, 12 months probation concurrent with count 2. And count 5 will merge with
Four.
count 4. So for a total of 12 months, probation, serve 172 days, credit for time served 86 days. That's from, the correct dates are from September 25th through 26th of 2023, December 13th through today, December 13th, 2023 through today. Stay away from all MARTA, 40 hours community service, 8-week anger management.
So the intent is to plead guilty to public drunk, terroristic threats, criminal trespass, and willful obstruction, 1 count. Is that right?
Yes.
Mr. Graham?
Yes, and we'll just ask the defense to stipulate to venue factual basis identification for purpose of the plea, and position 16 FTA will be on no pros.
For that purpose, we do.
Okay, anything further, Mr. McLean?
Nothing.
Mr. Harper, it's my understanding that in case 23 CR 005762Y, you wish to plead guilty to public drunk, terroristic threats and acts, criminal trespass, and willful obstruction of law enforcement officers. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Harper. As soon as you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay?
And Your Honor, if I may, just to make the record clear, the credit for time served, the period is from September 25th through 26th, 2023, December 13th, 2023 through February 27th, 2024. I apologize for that.
Okay, thank you. All right, good luck to you, Mr. Harper.
That's your information, so I'll turn that in. Thank you. I'm happy to meet you.
We go back to.
All right, be safe.
I got one thing.
Your Honor, just to reiterate for Mr. P.D. McLean, the state did agree to having the having the bond reinstated on Mr. I believe it was Mr. Harrell's or Braithwaite's case. And I know that I believe there was a order that P.D. McLean is going to have to do to have the bond reinstated.
Okay, you'll prepare that paperwork, Mr. McLean?
Your Honor, yes, I'm gonna come down to the Carnes building and do everything in person there. It ends up being faster than trying to
I agree.
mess with all these things.
So that means I'll be blessed with your grace of your presence in my office then, Mr. McLean.
That's right. If anybody needs lunch brought to them, I'm gonna stop by and get a sandwich.
So kind, so very kind. Okay. Who do we have next?
Judge, I believe earlier Officer Milton requested that I speak with, I'm sorry, Ms. Vanity Allman. I wonder if this is a good time to be put in a breakout room and do that so we can move to ACDC.
Okay, we can, and while I have you, Ms. Vigiletti, on the add-on calendar for Ms. Neves.
Yes.
You're requesting a reset till 3/7 on her cases?
Yes, Judge, I've been working with her for a couple of weeks along with our social worker. We're very close to getting her into a supportive program. And because the state is asking for 5 more days of jail time, we thought it wouldn't hurt to reset the case so she can, we can see about her admission into the programs.
Okay, that's fine with the court. It'll be reset until 3/7 on Thursday. So, how would you like to be placed into the breakout room?
I logged into Zoom, so you should see my name on my laptop. I can step out.
Okay,
Okay.
so. And can we have her, can we have her come back up so that we can go into a breakout room?
Excuse me, Judge Morrow, this is Blunt. Mr.
Yes.
Horace is wrong. He's not on 3 South. I've gone through all the 3-card books. So I'm gonna check medical and I'll let you know when I finish.
I appreciate it. Thank you. Okay, so let's place Ms. Vigiletti and AC/DC into a breakout room, and I take it that there's nobody else that we can take in courtroom 2. I don't see anyone else, so I guess we will be at
Okay, Judge.
That was Miss Grace. She jumped in and helped me out today.
Okay, thank you, Miss Grace. All right, so we will, I guess, be in recess until Ms. Vigiletti comes back or they locate someone else.
So Your Honor, this time I'll ask to be excused from this location, head downtown.
And have we completed all of your cases? Mr. McLean, what about position 3?
Oh, let's see. Mr. Barnes had already made his bond and was just surprised at how long it was taking to get him out the front door. So
Okay, so he's released?
Well, he expected to have been released by the time I visited him. And I said, well, I might see you tomorrow or not, depending on when they release you. It could take another day or 2.
Right. So I'm not expecting to see him today. I guess that's my question. Okay. I just want to make notes so that everyone knows.
Yeah, now that was his statement. I didn't try to confirm that, but he said, I made my bond. I don't know why I'm still here.
Okay. I guess you'll let the court know if that's not the case at some point in the future.
Right. If there's a problem, we can scoot him on to Thursday, I mentioned.
Okay. Okay, we'll be in recess until someone returns.
Ms. Fox, did you email me that restitution information?
I did. Did you not receive it?
Let me double check. What's been going on?
I
Yeah, I got
emailed
it. I see it now. I see it now. Thank you.
Okay,
I
not a
got a lot
problem.
of emails thrown at me.
I know. I
I'm
have seen,
multitasking here.
and I am the culprit for about 4 or 5 of them. So thank
Okay,
you.
I appreciate that. Thank you.
Big trouble was, I think, 2 or 3 days.
It sounds like the Irish, the troubles.
Yeah,
Trouble.
that's the thing we talk
Oh, it's Mitch. Mitch, that was pretty good.
Yeah, just remember this one. When you're counting, it's 1, 2, 3.
I'm from the
Yeah, you're from Mitchell County. Just remember, when you're counting, it's 1, 2, 3. When you're going to their front door, it's 1, 3, 2. There's 3 digits. Yeah, there's a parking lot, there's a sandwich shop, and then there's a front door, 2nd floor. You know, they have to walk up 1 flight of stairs, but they go there.
Position 33 and 34, Mr. Roan.
Have you had a chance to speak with him? You're on mute. Mr. Dodd.
Sorry, Judge, I need a breakout room to talk to him real quick. It shouldn't take long.
No, you're fine. Can I just put courtroom 2 in a breakout room with medical?
That'd be great.
Okay, so if we can put courtroom 2 and medical to a breakout room, please.
Okay, Judge.
Thank you.
How you doing? I'm good. They got anything good for us? Well, you missed it yesterday.
Your Honor, I'm ready whenever the court is. And Ms. Falk is going to be a plea.
Okay, and let's see. This is position 34, Mr. Roan.
That is correct, Judge.
Yes, good morning, Mr. Roan. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear me, Mr. Roan?
Yes,
Okay, we're doing this by video. Is that okay with you?
yes, that's okay, sir.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you, sir. You can place your hand down. Yes, Ms. Falk.
Yes, Your Honor. On this case, the state's recommendation is 12 months probation, and that is going to include, sorry, I just lost my place briefly. That's going to include 30 days of jail, credit for time served 15 days. That's going to be from February 19th to March 5th of 2024. The balance will be suspended. Stay away from 191 Peachtree Tower located at 191 Peachtree Street Northeast. And count 2, the willful obstruction, will be 12 months concurrent with count 1. Again, that will be balance suspended upon the stay away. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea, and that's all for the state.
Judge, we stipulate and ask the court to follow the state's recommendation And I explained to my client that he'll be receiving a time served sentence. He's gonna stay away from that location.
Okay. Mr. Roan, it's my understanding that in case 24 CR 000834, you wish to plead guilty to criminal trespass and willful obstruction of a law enforcement officer. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation? You've been you understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Roan. Good luck to you, sir.
Okay.
Thank you, Judge.
You're welcome. Mr. Haddad.
Yes.
You also have position 41, Torre is, it's my understanding that they're in Forsyth, and we're gonna have to reset that case.
No, Judge, he was actually brought this morning. I did speak to him. We're gonna waive arraignment and plead him not guilty, Judge.
Okay. So, Mr. Torre will be a waiver and,
Goes back to division, Judge.
all right, very good. Let's see, are we ready at ACDC?
Yes, Judge, this is positions 26 and 27, Brittany Love.
Okay, and what are we doing with Miss Love today?
Miss Love would like to enter a plea today. We did have a couple of points we wanted to discuss. So I guess the possibility of a non-negotiated plea.
Okay, good morning, Ms. Love. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, ma'am. You can place your hand down. Ms. Falk?
My mute was on, my apologies. All right, so this incident happened back in 2020, to be specific, May 2nd of 2020. Officers received a dispatch for a stolen vehicle at 954 Washington Street. They were able to speak with the defendant, Miss Love. They immediately observed she was under the influence of alcohol. She had slurred speech, stumbled when she walked, was unaware of where she was or exactly where she had come from, was unable to articulate herself, began screaming loudly, and leaned on the side of the patrol car so that she could remain upright and balanced. She stated she was not drunk, as she had just gotten out of jail, and reported that she had been at the gas station and had left her 2004 Mitsubishi Endeavor, went into the gas station to pay for gas, and claimed that someone had stolen her car. She stated that she then continued to give different versions of the event, began contradicting herself, stated multiple times that she was told her vehicle had been overturned, and then spontaneously stated to the officer, when my car flipped, I got out of the car, the people stopped, and they were asking me, ma'am, do you need help? Do you need help? And that point, the officer then asked Miss Love, so you were in your car when it flipped? She stated yes. And assured the officer that she was in the vehicle when it flipped. She also stated my car was upside down and I crawled out of my car. The officers then sent out multiple units working in the area. They were actually able to locate a vehicle accident at Central Avenue and Rawson Street, where the vehicle that matched Miss Love's vehicle had been overturned and a female driver had fled from the scene. At that point, the officer informed Miss Love of what had happened and his information, and that her vehicle was not going to be reported as stolen since she had clearly crashed her vehicle while she was intoxicated. The officer then spoke with Miss Rowe, who was a witness, and his wife. They both stated they observed Miss Love exit her overturned vehicle and then get into another vehicle and leave the accident site. At that point, she began yelling at the officers after completing the DUI testing, which she did fail. The officers then read her implied consent. She then began screaming profanities at the officer, called the officer, you know, I don't want to hear that B, get out of my face. Called him a white ass cracker. At that point, she was placed under arrest. The state's recommendation on this case is for the reckless driving, 12 months, serve 30 days, credit for time served 15 days. That's going to be from February 20th to March 5th of 2024. 40 hours of community service, DUI risk reduction, victim impact panel, and alcohol drug evaluation and treatment. The count 2 would be 12 months concurrent with count 1, count 3, 12 months concurrent with count 1 with a $265 fine. Count 4 would merge with count 1, the reckless driving. Count 5, which is the failure to report striking fixed object, would be 12 months to run concurrent with count 1. Count 6, the disorderly conduct, would be 12 months served 30 days, credit for time served 15 days from February 20th to March 5th, 2024, and that would run concurrent with count 1. And count 7 would merge with count 1. So it's just a total of 12 months, serve 30 days, credit for time served 15 days, 40 hours of community service, DUI risk reduction, victim impact panel, and alcohol drug evaluation and treatment. The state would say that the defendant has 4 cycles on her GCIC, and that would be a driving without valid license in 2016. There was no conviction that we are showing. She also had a 2020 hit and run, failure to return to the scene of an accident from July of 2021, where she received 24 months probation. So based on her previous hit and run where she fled the scene, and this case, well, actually that was a subsequent hit and run where she fled the scene, and then this case where she was DUI, we do have some serious concerns, which is why we deviated by asking for those DUI conditions on a reckless driving case. That's all for the state.
So Ms. Lewis is telling me what's a DUI alcohol listing charge? What happened with that charge?
Okay, and so let me just double check, Your Honor.
Yesterday, I sent out an email that I CC you on, Ms. Falk, saying that there was a accusation that was not filed out back then. There was on the clerk's ear of a DUI that y'all did file on this case. I think I let PD know about it, and I think I sent her a copy of those accusations and everything. So the first charge is originally a DUI, so it's a total of 8 charges instead of 7.
Oh, okay.
And yeah, I don't know why it was never caught throughout the
Right.
process. I ended up catching it when I was going through the files.
And honestly, I thought it was kind of strange, but I was willing to ride with it. So, so the state would modify based on that. We would like to go forward on the DUI. Quite frankly, this is a DUI case. I was a little surprised that we just had a reckless driving, but based on Ms. Lewis's information, that makes a lot more sense. So we would ask to proceed on the DUI and have the reckless driving then merge into the DUI. So the recommendation as it stands would still remain the same, but instead of everything merging into the reckless driving that we previously stated, we would ask that everything merge into the DUI. And then the DUI would be your 12 months, serve 30 days, 40 hours, community service, DUI risk reduction, victim impact panel, and ADET. Hopefully I didn't confuse everyone too much with that, but I can restate it if necessary.
I just want to make sure. So with the DUI less safe, is the reckless going to merge into the DUI? Or
That is correct, Your Honor. So count 1 would be the DUI, count 2 would merge, what would now be count 3, the false report of a crime, would be 12 months concurrent. Count 4, the failure to maintain lane, would be 12 months concurrent with the $265 fine. Count 5, which would be the basic rules, would merge with count 1, the DUI. Count 6, which would be now the failure to report striking fixed object, would be 12 months concurrent with the DUI. Count 7, which would be the disorderly conduct, would be 12 months with the 30 days, credit for time served 15 days, concurrent with count 1, and then count 8, which would be the second disorderly conduct, would then merge with count 7, the other disorderly conduct.
Ms. Vigiletti, given that, you need to speak back to Ms. Love.
It doesn't change the plea offer, Ms. Love. It just changes the conviction from primarily reckless driving to primarily DUI. Do we need to speak? Okay.
No.
Okay, I think we're ready to proceed.
Okay, all right, go ahead, Ms. Vigiletti.
Yes, Judge. So this is a case from 2020. I know you've heard about some other instances that Ms. Love had around that time, and we don't dispute what happened at that time. Our request today really involved what has happened since then. Ms. Love did have another incident last year in DeKalb that she does have a 7-year-old child. DFACS did get involved, and she completed last year a drug and alcohol evaluation and complied with some treatment related to DFACS monitoring. And so she's been telling me she's done very well since. She now has a stable housing situation. She's doing really well. You know, no out of control drinking, nothing like that. And so we did want to ask today if the court would consider proof of her recent participation in a DeKalb DFACS related alcohol and drug program as a replacement for the alcohol and drug evaluation and treatment. And similarly, because she has not been working, she's been working on kind of getting her feet under her, getting some stability. She did used to do restaurant work, but does not have a job right now. And so we also wanted to ask if you would consider either dropping this fine, because I could be wrong. I don't believe it's statutory on the case, on the charge that it's related to, or converting it to community service.
And Your Honor, I will kind of throw out there that because there is a DUI charge, there is a $300 statutory fine related to that charge. We are agreeable to dropping it on the failure to maintain lane or improper lane change, but there would still be the $300 fine to contend with on the DUI since that is statutory.
Okay, so no 265, but a $300 fine. I understand the fine is statutory, but if you want me to convert it to community service, I'm happy to do that, Ms. Vigiletti.
I would appreciate it, Judge.
Okay. Also, if she presents the paperwork to probation and they accept it, then and she complied with it after she received after May 2nd of 2020, and it complies with the type that they would have, that's fine with the court. So we can put that, but it'll be up to probation whether they accept it or not.
Okay, Judge. So
Okay.
Ms. Love, just send that proof to your probation officer, okay, of participating in the DFACS program.
Okay, so would I get a copy of all this? When would I meet them?
So when you're released, you'll report to probation. You'll get a message from probation about when to report. And when you show up, bring that proof, okay? That's what the judge is saying, that it's up to the probation officer, whether or not they want to take that.
Okay, cool, baby.
Okay.
Okay, and it's fine with the court. I mean, if she's in compliance and has already done it, it's fine with the court as long as probation accepts it.
Okay.
Okay, anything further before I take the plea?
No, Judge.
Okay, Ms. Love, it's my understanding that in case 22 CR 007386A, you wish to plead guilty to DUI less safe, false report of a crime, failure to maintain lane, failure to report striking a fixed object, and disorderly conduct. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated. Ms. Love, with what I have already articulated, good luck to you, ma'am.
Thank you.
We have next.
Judge, can you read her, status of her probation? Is it she want to remain? Or?
Right, if I don't say, then it'll be on probation for the
Okay.
entire time. Otherwise, I will, let you know.
Okay.
And Your Honor, the state is entering a null cross on position 27. Just wanted to clarify that.
Oh, yes, thank you. Okay, who do we have?
Judge, this is position 2, Vanity Allman.
Okay, and what are we doing with Ms. Almond this morning?
Ms. Allman would like to enter a not guilty plea today.
Would you like me to arraign her?
I can file a waiver.
Okay, Ms. Almond, your case will be returned to the division judge, and you'll get notification of your next hearing date. Okay, good luck to you, ma'am.
That's it from the ACDC, Your Honor. May we be excused?
Okay, we've done everyone there?
Yes, sir.
Okie dokie, will I see you this afternoon?
Yes, sir.
Okay, I'll see you in a couple of hours, Officer Milton.
Okay, but I only have
Okay.
one person.
Okay.
Thank you.
I'm missing
So-
somebody on the probation calendar, position number 9. Did I miss something? Rodney West on probation.
Right. So I've got that we haven't gotten to Rodney West yet,
Okay.
right?
And Judge Rodney West is not here. I haven't gotten an update on where he is.
Okay, he's not in the jail?
He's not, and he was also Mr. Haddad's case, and Mr. Haddad has left. I'm not sure if that means that he couldn't find him.
Okay, so,
I'm not sure if he's not at the jail or if he wasn't able to be located. I didn't
So
realize Mr. Haddad still had a case when he left.
all right, so it looks like we'll have to put him on Thursday's calendar. So Ms. Lewis, if we can put position 9 on Thursday's probation revocation calendar. And it looks like
Well, I
probation
found
has,
out why they can't find him. He's been released.
oh, okay,
He was
thank you.
Released on March the 1st on some other charges.
Right?
So we're waiting on.
Also to follow up this, I see the note now on the calendar that he's bonding that he will be set before a judge deadline for his revocation hearing.
Okay, does that cover everybody?
I believe so.
Your Honor, or PD, can we get a result on position 5 on the probation calendar? Ms. Vigiletti?
Yes, his case was closed, so that was a time served.
Thank you.
Yeah.
Okay, Ms. Lewis, whenever you're ready, I guess we can go over the calendar.
Okay. I'm gonna start with probation calendar. Add-on probation calendar number 1, Mr. Clark, who's position 1 and 2, his commute to time served. Position number 1 on the original probation revocation calendar, starting with Mr. Christopher Garrison, his commute to time served. Position number 2, Antonio Martin is continue on probation. Same announcement for 3 to continue on probation, complete his anger management class. Position number 4 and 5, defendant revoke the balance of probation, 10 days, balance suspended. Position number 6, commute to time served. Position number 7 and 8 on the probation calendar, Mr. Antonio Tuman was commute to time served. Position number 9 is going to be reset for the notice defendant was released. It's going to be before Judge Edline for a revocation hearing. That completes the probation calendar. Any questions on that? Okay. Sorry, I got all these calendars I'm jiggling right now. All right, we're gonna start with the add-on calendar of the state all purpose. Position number 1 and 2. 3, which is Alexandria Nevis, is going to be reset to the SAP counter for March the 7th, which is this Thursday. It'll be an add-on. Position number 4, Calvin Sims was a time served plea. I'm not time served. It was a plea. He got extra time. Sorry. All right, that take care of the add-on. We're going to the original counters for the state all purpose counter. Position number 1 was a plea. Position number 2, defendant waive arraignment, not guilty. Case is reset for trial further notice. Position number 3, defendant made bond and was released, reset further notice. Position number 4 and 5, defendant bond is reinstated from the last FTA, which is a $3,000 surety bond, and stipulate to condition with no further contact of the victim. Position number 6 was a negotiated plea. Position number 7 is being non-pros. Position number 8 was a plea. Position number 9 is non-pros. Position number 10 was a plea. Position number 11 and 12, the defendant was released on bond. The case is reset for the notice. Position number 13 was a plea. Position number 14 was a plea. Position number 15 was a plea. Position number 16 is non-pros. Position number 17 was a plea. Position 18 and 19, defendant was released on bond. The case is reset for the notice. Position number 20, defendant waive arraignment, not guilty. Case is reset for trial. Bond hearing was denied. Position number 21, 22, 23, and 24 are all going to be reset to the SAP counter for Thursday, March the 7th. That will be an add-on. Position number 25, defendant was arraigned, not guilty on the charge. On the prior SAP counter, the bond has been amended to a $5,000 SOB through the jail with the stipulation no alcohol, no drugs, and no weapons. And I'll be expecting a bond amended order from PD on that.
Yes, ma'am.
Position number 26 was a plea. Position number 27 was non-pros. Position number 28, defendant was arraigned, not guilty. Case is reset for trial for the notice. Position 29, defendant was released on bond. Case is reset for the notice. Position number 30, I have a note to reset this case for the SAP for the 7th of Thursday. Is that correct? That's on window.
That's what I have.
Yeah, I did put that in my announcement. Judge, I spoke to him and I just need a social worker to talk to him before I can, he couldn't focus on his case.
Okay, that's fine.
And I just want to make clear on charge number 2, Ms. Fox, on his counter, the jail has it as NOD. Is that supposed to be an NOD or is supposed to be a charge?
I will look into that for Thursday, so I'll have an announcement on Thursday.
Yeah, because the jail has it posted as not on docket.
Okay.
So they only showing that the theft by shoplifting is holding him.
Understood.
Okay. Position number 31 was a plea. Position 32 was non-pros. Position number 33 was a plea. Position 34 was a plea. Position 35 was a plea. Position 36 was non-pros. Position number 37 was a plea. Position 38 was a non-pros. Position 39 was a plea with extra time. Position number 40 was a plea. Position 41, waive arraignment, not guilty. Case is reset for trial further notice. Position 42 was a non-pros. Position 43 was a plea. Position 44 was a plea. Position 45 was non-pros. Position number 46 was a plea. That completes the call of our calendar and the results. Any questions or concerns?
Miss Lewis, is it relevant whether it's a negotiated plea or non-negotiated plea?
Yeah, it does, because I marked that on the calendar and make sure it's a non-negotiated plea.
Okay, so positions number 6 was non-negotiated.
Okay. Okay, I had it non-negotiated, but I thought it was negotiated after the judge had indicated. Oh, okay, that's fine. I got it, non-negotiated.
Thank you.
And I think that's it. Any other corrections? And I guess I'll be receiving a whole bunch of paperwork.
All right, thank you all. We appreciate it. It's a big calendar today, but we got through it. Thank you, guys.
Thank you.
All right,
Yeah.
thank you.
We'll see y'all next time.
All right, make sure you guys give me those non-pros. I think I got half of yours, Ms. Falk. I don't know about you, Mr. Graham. If
You
got 'em,
should
please send them to me.
You should have all of mine, but if you're still missing any, just let me know.
I
But
will.
I
And
sent
Mr.
them
Graham-
as we were going through the
Yeah, I
calendar.
saw
They
that. I
should have them.
appreciate that. And Mr.
Yeah.
Graham, you,
Mine should be with you in about 30 seconds.
I appreciate that. Thank y'all.
Thank you.
All right.
So they do it that way, if